Does a court have to consider allowing a psychiatric evidence defense that's more than 4,000 days late? To find out, you have to read People versus Sidbury, but it's 37 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Sidbury. The citation for this case is 2024 New York Slip Opinion 03318, published by the New York Court of Appeals on June 18th of 2024. The issue in this case, the primary issue in this case, is whether a trial court erroneously precluded a defendant, didn't allow a defendant to present a psychiatric evidence in his defense because it was more than 4,000 days late. A secondary issue is whether evidence is legally insufficient to convict a person of arson in the second degree when it's consisting of a cuffing port, which is like a metal box inside of a prison jail door of solitary confinement. The background in this case, it's important to understand, is under CPL 73030 is a statute. Criminal Procedure Law 73030 talks about competency to stand trial. And a defendant who's not competent to stand trial cannot be tried. You can't put a defendant through a trial if they're not able to understand and appreciate what's going on around them. That's different than a CPL 25010 defense. A CPL 25010 defense is a defense based upon psychiatric evidence that talks about whether the defendant was capable of forming the mens rea, the thought component, at the time of the crime. So the difference is that a 73030 issue is about right now, if the defendant is not capable of being tried right this very moment. And a 25010 defense is about whether the defendant was capable of forming intent at the time of the crime. It doesn't matter about right now. It's about the time of the crime. And the concept of 25010 is its basic requirement that within 30 days of arraignment, 30 days of being formally charged and presented the accusatory instrument in court, within 30 days, the defense has to present a 25010 defense, written notice of intent to present a 25010 defense of lack of the ability to form the mens rea and intent to commit the crime. It's basically the mental disease or defect defense, where either a person has extreme emotional disturbance, lacks criminal responsibility by reason of mental disease or defect, or some other defense of that nature, a psychiatric-based defense. Now, although the statute says it has to be done within 30 days of arraignment, the court has discretion to permit late notice of that defense in the interest of justice and for good cause shown, okay? And it can do so even as late as the trial, including after the trial is commenced, but the decision to permit late notice rests with the trial court. The trial court's supposed to weigh the defendant's constitutional right against the resultant prejudice to the people from the late notice. Okay, what are the facts here? The facts are this defendant has a very, very, very long history of psychiatric issues, starting back when he was in daycare. He was first prescribed psychiatric medication at 10 years old in foster care. He attempted suicide. He was psychiatrically hospitalized multiple times, diagnosed with borderline personality disorder, antisocial personality disorder, bipolar disorder, all kinds of history of psychiatric issues. In 2013, at the age of 20, the defendant was charged and indicted for murder in Kings County, Brooklyn. He was incarcerated in Rikers Island pending after that arrest, pending that trial. And in Rikers Island, his mental illness did not go away, and he had a number of new arrests in Rikers Island for his actions there, for assaults and injuries, including while he was in solitary confinement one time, he basically is alleged to have set a fire in the cuffing port. The cuffing port's like a box, a hole cut out of the metal, cut out of the door that has two doors that open up. So a guard can pass food or water or books into this box and then close the door. And then the defendant, the inmate, can open their side of the door, take out the food, water, books, all that stuff. Or the officers, the corrections officers, can handcuff. That's why it's called a cuffing port. They can reach in, or they can have the defendant put his hands outside the door, handcuff him from a safe distance where they're not going to get hurt. The defendant can't hurt them, the inmate can't hurt them, and then they can close the door and open the solitary confinement door while the defendant's already handcuffed. Okay, so it's alleged the defendant set a fire inside of that cuffing port, which is theoretically, according to testimony, fireproof. The inside of that cuffing port is fireproof. He was charged with arson in the second degree. Arson in the second degree is setting fire to a building. So one of the questions ultimately in appeal here is a cuffing port part of the building? The defense counsel, who was represented by Legal Aid Society, never raised this psychiatric defense, this 250-10 notice, for more than 4,000 days. 4,000 days, more than 4,000 days after arraignment. Finally, the trial is 56 days away, approximately. And for the first time, the defense counsel says, hey, judge, we want to present a psychiatric defense here. And at that point, the judge gets very upset and says, denied. I'm not letting you. I think the defendant's malingering. He'd apparently had many interactions with this judge over the years this case was pending. And the judge said, I'm denying your application. No. So he never asked the people for what the prejudice would be. He never inquired further. He just said denied because it's so late and I don't believe it. Okay. There's no psychiatric defense allowed here. The defendant was subsequently convicted of arson in the second degree, sentenced to 25 years in jail. He appealed to the appellate division, and the three issues here were, was the judge wrong to not even allow him to, was the judge wrong to not even consider properly the psychiatric defense? Was the evidence legally insufficient? And was the trial counsel ineffective for not requesting a lesser included arson 4 instead of arson 5, or arson 5 instead of arson 4? Basically, the court in this decision here, the holding is that they go through it and they reverse it. They reverse the conviction and they say why. They say the Sixth Amendment to the Constitution requires compulsory process to call witnesses in their favor. The defendant has a right to call witnesses. And yes, it can be precluded. The defense can be precluded from calling witnesses if they're late, but it has to be judged, has to be based upon an evaluation of the merits, of the prejudice and the probative value here. So preclusion, the remedy of preclusion, which is what the judge here said, he said, I'm not letting you put that evidence forward. I'm not letting you do that defense, is justified only when the violation amounts to willful misconduct that's designed to obtain a tactical advantage, or when the less severe penalty would perpetuate rather than limit the prejudice. Here, the judge violated and abused its discretion as a matter of law. Why? Because it didn't inquire and find out about the prejudice. The 4,000 days is not by itself sufficient prejudice inherently to allow a judge just to deny the application. The judge had to have and did not properly evaluate the prejudice and therefore abuse its discretion as a matter of law. As to whether a cuffing port is part of a building, yes, because it's part of the door's functionality. And at the trial, his counsel had conceded it's part of a building. So the big issue here is the big holding in this case is the judge must consider, even if it's 4,000 days late, an application to advance a psychiatric defense. And that's the case of People versus Sidbury. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.